Okay, I think we're ready to go. Thank you all for being here for the last of our student scholars presentations this year. This series was instituted 12 years ago now in order to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference style setting. I'm Professor A.G. Harmon. If you any visitors here today, we welcome you. Today's presentation will be made by third year student Mark Nobile. Before I introduce Mark, let me say a few words about the respondent to his presentation, Professor Susanna Fisher, who's kind enough to serve in this role today. Professor Fisher joined the faculty of the Columbus School of Law in 1999, where she teaches here, or has taught, a variety of courses in the fields of creativity, constitutional law, and comparative law, including art law, music law, entertainment law, copyright law, comparative constitutional law, and constitutional law, straight old constitutional law. So she has obtained her legal education at Merton College, University of Oxford, where she received a BA in jurisprudence, and the University of Virginia School of Law, where she was awarded the LLM. She is the director of CSL's International Human Rights Summer Law Program in Rome, and the co-director of our law school's Siegenthaler Sutherland Cup First Amendment moot court competition. So, of course, always delighted to have her to serve in this role, and thank her for doing that today. So as to Mark, Mark graduated from Fordham University with a BA in economics in 2017. He is the production editor for the Journal of Law and Technology for volume 29, and was selected as a Plato Papst Fellow during his first year of law school, which is awarded to first-year law students who demonstrate interest and potential in the field of labor law. He clerked for a year with Mooney, Green, Sandon, I hope I'm saying that, Murphy and Welch, a DC firm specializing in union-side labor and employment law, and hopes to work in union-side labor and employment law in the DC area after graduation. He is a lifelong sports fan, and the field of sports betting has always interested him. The Supreme Court's decision in Murphy versus National Collegiate Athletic Association, which lifted the federal ban on sports betting, was issued in May of 2018, roughly the same time as when he made his decision to attend the Columbus School of Law. He decided to research the subject after reading an article which suggested that online sports betting would potentially expose cybersecurity weaknesses if the issue was not addressed prior to states creating their own sports betting industries, since the industries would have a uniquely online presence. So that is the thrust of his article's topic, and shows you why this topic piqued his interest. I'm going to now turn the floor over to Mark to present his work, which is entitled "Bet on It: The Complicated History and Uncertain Future of Sports Betting in the United States, and How the Growing Industry Might Affect Technological Advancements." Mark, it's all yours.
Thank you, Professor Harmon. Appreciate it. I'm just going to take a moment to share my screen and begin the slideshow. All right. So, as you heard, my name is Mark Nobile, and this is Bet on It, which will discuss the legal status of online sports betting. Before I get too far into this presentation, though, I really want to just hammer home the three elements of my research, just to be absolutely clear about what we're discussing today. This is online, meaning bets made over the internet or with a mobile device, as opposed to, say, going in person and placing a bet in a casino. This is sports, as opposed to online poker or daily fantasy contests. And this is betting, wagering on the outcomes of certain professional sporting events. Put those together and you get my topic, online sports betting. So the federal ban on sports betting was ruled unconstitutional in 2018. In the roughly 2.5 year span since that decision, sports betting has become an area of rapid legislative action. 25 states and the District of Columbia have either already legalized sports betting or will have such an industry in place at the end of this year. Now, of those states, only 11 of them, which is less than half, currently have online sports betting options or a realistic plan to implement them this year. Some of those states made it very clear they simply do not want the headache involved in online betting, while others think it is an area that needs to be determined independently, with laws and regulations specifically tailored to such a unique industry. Now, despite the reluctance, I can say with confidence, sports betting will likely be a very large online betting industry. As you note on the side there, the revenue-raising potential of online betting has been estimated at as high as $150 billion back in 2015. And while that number has been subject to some debate since then, that number is simply just too high for the majority of states to pass up the potential to raise such lucrative revenues. But there really are unique problems that need to be solved before legalizing and establishing this industry. There's so many cybersecurity and consumer privacy concerns that can arise just out of any sort of online presence. With online betting specifically, users often need to provide things like their legal name, their date of birth, and their permanent address to prove that they are of legal age to make bets and to prove they live in a state where sports betting is legal. They often have to provide social security numbers, bank account numbers, and credit card numbers to establish a cash flow for their account as well. Further, this industry could prove to be a logistical nightmare. Copious amounts of data would be transferred and stored every single day. And it's often wondered whether private companies, casinos, or even state-run lotteries can be trusted to handle all this entire industry on its own. But before we really get into those concerns, I think we need a brief overview of sports betting laws in the United States. Prior to the 1960s, there was a frequent moral opposition raised in terms of betting, but there were no federal laws banning sports betting. As time went on, it became clear that some organized crime groups had the influence to rig sporting events and win lucrative payouts to fund illegal activities by betting on the outcomes they knew would happen. I think the most famous of this example, you may have heard of it, is the Black Sox scandal, where the 1919 World Series is allegedly rigged by a New York City crime organization, paying off 8 players on the White Sox team to purposely lose so they can bet on their opponents. As this overlap between organized crime grew and became more recognized and established, narrow laws meant to curb the criminal aspect of sports betting were passed. One of the most famous is arguably the Federal Wire Act of 1961. It made it a criminal offense to knowingly use a wire communication facility, which has since been interpreted to include things like phones and the internet, to transmit bets, wagers, or any information aiding betting industries. But I should note that Robert F. Kennedy, who was the Attorney General at the time, made it clear to Congress that the Federal Wire Act was not meant to criminalize friendly wagers on sporting events, even if these friendly wagers passed through interstate commerce, and even if they were relayed through wire communications. The Federal Wire Act did not aim to curb sports betting itself, only to hit criminal organizations where it hurt, where they made the money. As time moves on, the overlap between organized crime and sports betting begins to dissipate. By the late 1980s and early 1990s, 4 states, Nevada, Oregon, Delaware, and Montana, all had state-sponsored betting industries. More states sought to follow. So the Senate Judiciary Subcommittee on Patents, Copyrights, and Trademarks held hearings to determine the legal status of the sports betting industry. The main conclusion from these hearings was that sports gambling still greatly affected interstate commerce, even if these industries were run legally by states rather than by criminal organizations. The Wire Act simply was not enough. Pictured there on the bottom right is then New Jersey Senator Bill Bradley. He was a professional athlete himself prior to being elected to the Senate, and he actually was one of the sponsors in Congress of the bill that eventually became the law known as the Professional and Amateur Sports Protection Act of 1992, or PASPA for short. The important part is that PASPA made it unlawful for a government entity or for a person to sponsor, operate, advertise, or promote any sort of gambling scheme based upon the outcome of professional or amateur sports games. Put another way, people could not run gambling operations for sports betting. Now, there were exceptions to PASPA. The highlighted one, Section A3, is of particular importance to the story. It allowed for states to establish sports betting pools in casinos, so long as a state statute made it legal prior to PASPA's effective date of January 1st, 1993. These casinos must have been in operations for a 10-year period in that state as well. Critics and analysts have noted at that time that that exception was pretty clearly applied only to one state, New Jersey. New Jersey at the time had the Atlantic City casino industry, and it was growing rapidly and seeking to be an East Coast competitor with Las Vegas, where, as I mentioned, sports gambling was legal. Also, that first section, A1 and A2, allowed states like Nevada, Oregon, Delaware, and Montana to grandfather in their legally established sports betting industries prior to PASPA. So they were still conducting sports betting. So Atlantic City casino owners, in that 6-month span that they had to capitalize on the exception, they cited their concerns that they would be unable to compete with Las Vegas without a sports betting industry. One Atlantic City casino mogul, famous for his role in Home Alone 2, Lost in New York, was quoted saying of the sports betting industry that, quote, "It's vital keeping your taxes low, it's vital to the senior citizens, and it's vital to putting the bookies out of business. All compelling arguments, and all arguments often cited by many critics of PASPA." However, a divided New Jersey legislature was unable to pass a state statute legalizing sports betting, which ironically would lay the groundwork for PASPA's eventual repeal. Before we get there, there's one last relevant piece of PASPA-era history, the Unlawful Internet Gambling Enforcement Act, 2006, or the UIGEA. The important aspect of this act is that it prohibited gambling businesses from knowingly accepting any sort of payment from a financial institution to settle unlawful, that becomes important, unlawful, to settle unlawful internet gambling debts. Now, like the Wire Act, the UIGEA is still in effect today, despite the fact it was passed to build off of a law that has since been repealed. Getting to that, in 2012, the New Jersey legislature passed the Sports Wagering Act. This legalized sports betting in New Jersey and aimed to establish a state-run sports betting industry by the next year. The many professional and amateur sports leagues sued then-Governor Chris Christie, claiming that the Sports Wagering Act violated PASPA. In response, New Jersey contended that it likely did violate PASPA, but argued that PASPA was unconstitutional. This case would eventually reach the Supreme Court in 2018 as Murphy versus the National Collegiate Athletic Association. In that case, 7 justices found that the main section of PASPA violated the 10th Amendment's prohibition on commandeering the states, while six of the 7 justices also found the unconstitutional portion of PASPA was not severable, meaning the entirety of PASPA was unconstitutional and therefore should be repealed. The Murphy decision basically made it clear. The legality of sports betting is an issue left entirely for the states. There is little room for the federal government to blanketly ban sports betting. Rather, the federal role for the federal government is to provide a regulatory framework or guidance framework to guide the states who do decide to legalize sports betting. Justice Alito made this very clear in the majority opinion of Murphy. Despite this, no comprehensive federal regulatory framework or guidance has been passed in response to the Murphy decision. So this brings me back to the main conclusion that I basically stated earlier, which is sports betting will be an online technology-driven industry. I can say this with confidence, and if you don't believe me, allow me to introduce you to Tennessee, which is this southern state here, south of Kentucky and west of North Carolina. Proponents of the sports betting industry considered Tennessee a long shot state even after the federal ban on sports betting was lifted. Tennessee has almost no market for sports betting in general. And on top of that, it is a state where many members of the legislature have adamantly stated strong moral opposition to the legalization of sports betting. So did the governor, who would have had to sign this law in order for it to pass. So why am I focusing on long shot Tennessee? Because in April 2019, despite all of the long shot concerns, they passed a law which exclusively legalized online sports betting in their state. If Tennessee can legalize online sports betting, then many states also can and will. Moral opposition alone is likely not enough to keep states from pursuing a lucrative revenue-raising opportunity. Now recall, this is an area of much legislative activity, and roughly 11 states will likely have true online sports betting industries by the end of this year. As we've established earlier, betting sites will have access to their users' sensitive information. And one might assume that requiring the strictest security possible for every betting account is the best course of action. But consider a situation where a user has a great idea for a bet, just a mere moments before the betting window closes. Now imagine that his account is so secure that it takes this user more than a few minutes to access his account. He misses the opportunity to place his bet, and anger ensues. Cybersecurity regulations can't force companies to treat betting accounts like metaphorical bank vaults. There is a unique user accessibility requirement that must be considered in this industry, unlike other industries. Now, according to a recent article from Business Law Today, many states have already undertaken efforts to address consumer privacy protection in cybersecurity. These laws that are being considered are broad in scope, and they will serve to protect online sports bettors, even though these laws aren't specifically tailored to the online betting industry. These laws address things from privacy concerns to the handling of data breaches and regulations for storage and destruction of sensitive information, among other things. But it should be noted, and it was noted in this article, that these laws may not address certain specific issues specifically in the sports betting industry, such as the aforementioned accessibility requirements and even website security measures. And it should also be noted, in this article, that there currently is no comprehensive, broad federal cybersecurity or consumer data protection law. Now we move to the topic of centralization versus decentralization. According to a January 2021 publication, there are over 31,000 businesses participating within the sports betting industry all around the world in 2020. And that number has consistently risen since the 2018 Murphy decision. Often these industries are run by some central governing body and usually are dominated by private companies like FanDuel, DraftKings, or casinos. This topic provides for an interesting question. Quis custodiet ipsos custodes? And if you're not brushed up on your Latin, that means who guards the guards themselves? In the centralized industry, governing bodies dictate things from planning to decision-making to strategy, policies, management, etc., you name it, with minimal oversight from another body. These private governing bodies, which the aforementioned DraftKings, FanDuel's, Casino, their presence raises a concern of potential abuse or misuse. An example specifically from the sports betting industry of such misuse could have been seen in 2018, in the early days of the post-Murphy landscape, where FanDuel refused to pay out a bettor named Anthony Prince, who put down a $110 bet with very, very long odds of panning out. Even though the bet was unlikely, he won and was owed by FanDuel over $82,000. FanDuel, in response, refused to honor this bet, citing that there was an error in the calculations that only they controlled. They didn't take responsibility, and they refused to honor Mr. Prince's winning bet. FanDuel instead offered Mr. Prince significantly lower payout, and a company representative is alleged to have said, quote, "You should take what we give you because we don't have to give you anything at all." And Mr. Prince is quoted of the fiasco, and it's a good quote, "The government is taxing it meaning sports betting. So I thought this would be a better situation." After a smattering of bad press, FanDuel did pay out Mr. Prince's $82,000 bet, but noted they didn't have to and refused to take any sort of responsibility for the issue. Furthermore, like many tech companies like FanDuel have the power to sell or misuse the information they have collected in the absence of regulations or laws preventing them from doing otherwise. And even if we're to assume these private betting companies do play by the rules, there's always the possibility that their websites simply can't handle all the internet traffic they would potentially attract during popular events. To hammer this point home, consider this year's Super Bowl. BetMGM, Barstool Sports, FanDuel, and DraftKings, four of the biggest betting websites, all had their mobile betting sites crash for most of the Super Bowl due to the demand and traffic of their websites far exceeding their capacities and expectations. Now, proponents have noted that this is a sports betting, online sports betting specifically, is an industry that could be a very good candidate for decentralization. The term decentralization is somewhat hard to pin down, but basically it just means powers are taken away from central governing bodies and dispersed among many decentralized self-governing bodies. Some tech pundits have even argued that DAOs could replace private companies in the betting industry. And that raises the question, what is a DAO? Well, DAO stands for Decentralized Autonomous Organization, and it denotes organizations that have their rules encoded as part of a computer program. This means there's minimal to no human oversight in enforcing its rules in day-to-day functions. DAOs govern themselves. Proponents of DAOs note that DAOs remove the temptation of misusing users' information. Once a user logs in, their data is encrypted and accessible to only a few people, if any at all. And because DAOs require little to no oversight, there can be more of them, which would address traffic concerns. And finally, odds could be objectively set based on internal coding, and payouts would be based on the internal coding as well, rather than human action. Now, critics of DAOs have noted two issues. First is that any sort of bug or security issue in the code could be very difficult to address. Once a DAO is launched, the code is publicly accessible to anybody, but almost impossible to change. This means that security faults can be found and abused, but not fixed easily. In 2016, for example, we saw the first large-scale functioning DAO launched. It was conveniently called the DAO. The DAO, in its first month, lost $50 million due to an easily exploitable security issue in its coding. These issues could not be fixed, and the DAO was delisted and abandoned, despite being a roughly $150 million investment with over 11,000 investors. Legal scholars have also noted that DAOs have uncertain legal status, with some scholars noting that DAOs may function like a corporation without the liability shielding aspect of a corporation, potentially exposing them to unlimited legal liability. So now we move to the last portion, the relics of the past. Both the Wire Act and the UIGEA are currently valid and enforced laws, which is true, even though the legislative landscape of the sports betting industry has changed drastically since both two laws were passed. Now, some can argue that both laws have outlived their original use. Consider the Wire Act, which again makes internet transmission of betting information across state lines a federal offense. Some argue that the Wire Act's prohibition on interstate online bets criminalizes convenience. If it's legal to drive into another state and place online bets within their borders, why criminalize bettors from doing it in the comfort of their own homes? Without the Wire Act, moving on to the UIGEA, there are almost no illegal online bets, meaning the Wire Act may be the only thing keeping the UIGEA alive, at least in the sports betting industry. Now, I want to note, I don't think it makes sense to outright repeal either of these laws. There is definitely legitimate concerns about, say, international offshore betting websites. I think maybe amendments that would criminalize the international aspect of betting would make more sense and fall in line with the Murphy decision, because it would ensure that the states are the ones making the money rather than made abroad. So in conclusion, I think it's established that states do face many difficulties that are unique to their emerging online sports betting industry. Although Murphy essentially makes it unlikely for the federal government to implement another law banning sports betting outright, Congress should consider to provide regulations or guidance for states as soon as possible. Although decentralizing the sports betting industry provides for exciting opportunities, the current status of blockchain technology leaves decentralizing the industry unlikely. I do think, however, federal regulations or guidelines should be passed to standardize how each state treat their governing bodies. And finally, the Wire Act and the UIGEA should be amended rather than repealed, focusing on international betting rather than interstate betting. Thank you for that. I turn back to Professor Harmon.
Thank you, Mark. Very interesting topic and great handling of it. I'm going to turn things over now to Professor Fisher. She'll conduct about a 10-minute response, and then we'll have questions from the audience. Professor Fisher.
Thank you. So Mark, I want to say thank you for a wonderful presentation, and I would echo Professor Harmon's praise for your delivery and your excellent slides. Really interesting. I'd also like to thank Professor Harmon for running this series. It's a wonderful opportunity for students to present their work to an audience. So I also, Mark, I loved your use of Latin. I'm so happy that people actually, law students should, of course, have a working knowledge of Latin, in my opinion, and especially the Catholic University of America, very apt. So it made me think about gambling in ancient times when Latin was actually spoken. And your topic, in fact, has a long history. An issue of gambling regulation was certainly an issue in ancient Rome. And gambling, except on certain holidays, was outlawed in Rome, both during the Republican period and the imperial periods, because the government was concerned about several issues. One was angry people resorting to violence if the bets didn't go their way. And another thing they were worried about was, that descending into a riot. And as happened, interestingly, in like Justinian's time, when everyone was a member of the blue and green chariot factions, and there was a huge slaughter in one of the stadiums during that time that killed thousands of people. The government was also afraid of magic, which perhaps it's not so concerned about today, because some gamers and some racers in chariot racers claim to use magic to ensure victory. So that's an interesting concern that perhaps we don't have now. Now, despite these bans, many emperors were very fond of gambling. And for example, the Emperor Claudius had a special carriage that he rode in that was designed to allow his friends to gamble with him on long journeys to pass the time. The Emperor Augustus once lost 30 times the amount that a soldier earns in 1 year. And a notorious emperor cheater was, of course, Caligula. You might not be surprised to hear that. He cheated. And the Emperor Lucius Verus was probably the biggest gambler of all because he gambled every single night. But it's interesting that in ancient times, they had many, human behavior remains the same. And they had, kind of similar concerns and issues that the government had when it comes to regulating betting, and in particular sports betting, because in ancient Rome, they were betting on races and also games like board games and things of that nature. So one question I wanted to ask you about was, you referred to these moral objections to gambling, both at the very beginning of, sort of concerns about gambling, and sort of said that some states, even today, have expressed those moral concerns. So I'm wondering, what are the moral concerns today about gambling that might stop states from actually legalizing it post-Murphy?
Sure. Thank you, Professor Fisher, and thank you for that great stuff on Roman history. I find that very interesting, so I'm glad you added that. I think the most compelling argument I found on a moral level was raised in the Kentucky legislature. I have it written down here. Of course, they just dropped it. A member of the Kentucky legislature said, quote, "The people of our it is immoral for the people of our districts to lose money so that our state can gain money. I think that is really a lot of legislatures, a lot of moral objectionists kind of raise the concept of almost like it's a deception. You know that some more people are going to lose than win. So it's almost like states engaging in theft or deception from their people. And I do want to note, though, that a very good counter argument that I've heard to moral objections was that PASPA had so many, which, PASPA was the big federal law against sports betting, and had so many exceptions, including some that I didn't get to mention, like a blanket exception allowing for horse race betting, which is ironic to consider in Kentucky because horse race betting is, I think, roughly about, I don't know how much, but it's a large industry in in that state's economy.
What about gambling addiction? Do you think that that is a concern for sports betting as it is for other, kinds of gambling?
Yes, I do. And I think there are ways to address this while also legalizing sports betting, similar to how there's, I think, one important thing that I don't know why all states don't have it, but the 21-year-old requirement. Some states allow for 18-year-olds to bet. I think it's a bad idea. But then I think there are other things you can do which limit how much a person can lose, say, in a month. And you lock them out of their account if they lose more than, I don't know, let's say a regulation sets it at $750 a month. Obviously, that might be a little high, but I think it's a legitimate objection, but it is something that can be addressed with regulations rather than a ban.
Mm-hmm. And so, I think since you wrote the paper originally, as you acknowledge, the post-Murphy state law on which states are legalizing sports gambling is changing and has changed really rapidly. And so we're left, I think, if I understood what you were saying correctly, with very few states being in a situation where they don't allow any sports betting or are unlikely to be allowing it in the foreseeable future. And so there's some, like, I think those would really be Hawaii, Idaho, Alaska, and Utah that are kind of in the never category. And then you have some long shots that are like Alabama, Nebraska, and South Carolina that are long shots, but maybe could follow the example of Tennessee. I don't know what you think about that. And then there are states where sports betting would likely come only through the Native American tribes. So Wisconsin, Oklahoma, Minnesota, and California. So that totals not very many states, where we're likely to have none. And so I'm wondering, does that mean that states are not as concerned about these technological issues of hacking and cybersecurity as one might think? And if not, what are they really concerned about?
Well, I think what you hit on is that it's there's so many different moving parts, including the cybersecurity concerns. But I think I've found I have a couple notes here. I found that a lot of states either would vote to legalize it, but not implement an industry until they had certain cybersecurity requirements met, or they established that they would not consider online betting until later down the road. And for example, I can tell you that Louisiana, they had already voted at the parish level, which is what most states would call counties. They voted to legalize sports betting in the state, but they're considered not likely to have sports betting laws by the end of 2021 because the legislature is concerned with first establishing a regulatory framework that addresses online access and cybersecurity before moving forward in any regard. So I think the answer is there are many moving parts, and cybersecurity concerns definitely are one of them.
Yeah, and it's interesting because this is an area that sort of parallels some other areas of intellectual property issues, like encryption for copyrighted works, where you have one method of regulation, which is law, and then you could say another method of regulation, which is technology. And so I'm wondering what the state of particular technologies are that are developing to deal with the technological problems that you're talking about, like cybersecurity and hacking. And, is it possible to develop, or, are we on the road to developing effective technological protections? And if not, how does the law operate to back up ineffective, technological protections?
I think the best way I can answer this is that I really think there are just there are existing technologies out there that would strike the golden balance between accessibility and security, without even necessarily requiring laws. I think one of the just most simple things that can be done is two-factor authentication. I think, if just to kind of establish what that is, just real briefly, it's like you enter a password and you have, say you get a text message sent to your phone with a code. And it's such an easy fix, and it's so easy to do, that I don't understand why these websites that have such sensitive data aren't just making it mandatory. They make it optional. But I think essentially there's a lot of technology out there like two-factor authentication that would just really serve to really be an easy fix to this, rather than requiring laws or even crazy technological advances.
And so you mentioned that you have these kind of weird laws that are existed pre Murphy and are still on the books, that are the Wire Act and the UIGEA. And, so you suggested that you didn't think that those laws would be repealed. But if they were, what effect would that likely have, if any, on state regulation?
I think the best answer to that question is to provide an example of some weirdness that the Wire Act seems to have caused. In Colorado, bets must be made and processed exclusively inside Colorado state lines. Some pundits have noted that this section of the regulation was passed to comply with the Wire Act's prohibition on transmission of interstate betting, and specifically noted that this whole processing in Colorado was somewhat unreasonable. It was a brand new industry, and these were expensive and time-consuming and complicated servers that needed to be set up, when theoretically they could have just sent that information to a state like Nevada and paid a fee and had them charging there, rather than doing it in their state lines. So I think there's just some weirdness that happens when you kind of just make a broad law, like where it's just transmission of betting information across state lines is illegal.
But you suggested that the offshore situation is more of a concern.
Yes, and I think really all that has to do with is, in the spirit of Murphy, the sports betting industry is allowable to give states the opportunities for these revenues, not necessarily offshore accounts or offshore companies. So I think it's just amending the Wire Act to focus on international betting makes a little more sense and kind of aligns with Murphy.
So in your research, again, you suggested that Murphy is pretty much meant that the federal government is unlikely to ban sports betting in the conceivable future, that is just not going to happen. And then you suggested that any movement at the federal level would be regulatory. So, I'm wondering if in your research you have seen any movement in that direction, and if so, where would it go?
So a few months after Murphy, a different Senate Judiciary Subcommittee, I think it was the Senate Judiciary Subcommittee on Crime, Terrorism, and Homeland Security and Investigations, they held hearings to discuss their role. And essentially they highlighted really two main aspects of their role, which was first to use the Wire Act to target fraudulent industries, implying maybe like a betting industries without state approval, essentially. And then they also noted that another role for them, besides the, and I'll get to the regulatory aspect, but another role besides the regulations could be that their goal is to help ensure that the integrity of professional sports and amateur sports contests are being taken into consideration. One interesting aspect that was raised during those hearings was that most states didn't have a means for the sports leagues to essentially petition state gaming commissions to remove a certain bet that they felt may harm or even just was offensive to the leagues. So the federal government kind of noted that on top of their regulatory scheme would be important. And then just to note real quick, there are very specific federal laws dealing with like handling sensitive information. I think of HIPAA with healthcare information. So I would just note that a lot of analysts have noted that a potential online sports betting federal law specifically tailored to the online security is something that could happen as well.
Yeah, because I think I would agree with you that in privacy, we're definitely seeing a movement strongly affected by the GDPR about kind of concern for people's personal data that they release online, in part because of some of the bad things that has happened to that kinds of data. And so, in this area, we've just seen Virginia legislating, and prior to that, we saw California legislating actually twice, legislating and then in the CCPA and then amending that. So, definitely it's I would agree with you that this is part of a kind of broader concern over people's, control over their personal data, not just in the sectors where we already saw it, like HIPAA for healthcare, and what you guys as students are familiar with, FERPA, for your educational privacy records. So I don't want to monopolize the time, and I want to make sure that you, the audience, have a chance to engage with Mark a little bit on these issues and ask him some questions. So I'm going to throw the floor open to all of you.
I'm going to ask the first question. I want to ask Mark this. What was Dual Fan's argument that I didn't get that. Why did they say they had a right not to pay the money? And I guess that's what I fear is, and maybe it needs to be looked at in all these things, is that, there's no transparency. They say that something happened internally. This was something, it seems how do you ever find that they're lying to you? And I assume that's what they were doing.
Yeah, I mean, they really didn't go into it other than just to say, even though they were the only ones that could have done anything, it wasn't their fault. It really just was kind of an issue of nobody was kind of watching over them, so they felt like they might be able to get away with it.
What was the recourse then of how did they make him turn it loose? Was it bad press? I mean, did he have any legal rights? Could he sue them at contract? Is there anything that is provided for and should that be part of this, that, if you're a bettor, that you have some rights against these people?
Well, I think that's a definite possibility, but he didn't really seem to have many legal rights. I know he didn't think he was able to sue. He just tried to fight it with bad press, and it truly was, they got smattered with bad press on Twitter, and that's essentially what motivated them, I think.
Anybody else have a question for Mark right now? You can just raise your hand or let us know. I have one other question before, in case people have other questions. Tell me, is the data any more sensitive that you provide to sports bets than it would be in other areas? I mean, it looked like you had to say a lot in one of your earlier slides. You had to give them a lot of information. And of course, that would seem like, because of that, it would be, for a hacker, it would be a gold mine of information to want to get, so is this data more sensitive than you have to provide to get, to do other things? Go ahead.
I think for just like general other like consumer or entertainment, recreational, online things, I think it's very high. Like a lot of information gets transferred. I guess because there's the whole issue of having to transfer in and deposit money, but it really is kind of like if you think about it, you don't have to give your social security number to use Netflix. So it definitely feels like a more sensitive area, despite being just a recreational area.
Yeah, and does that very fact make it more? It just seems like it would attract more vice because of that. I think that's one of the things from Professor Fisher's question was about the moral objections. I mean, a lot of the people who always objected down south about things like this is that, well, as soon as you start that, then that's going to bring in this thing, and that's going to bring in that thing, and that's going to bring the other thing, and then it's going to get organized crime, and it's the camel's nose kind of thing, and I guess that's what worries people.
That pretty much hits the nail on the head. It's just it's a difficult situation because of like I noted with PASPA, they obviously were willing to live with the vice, so now they just have to regulate the vice.
And I guess, some of it is now concerns about the double sort of impulse control issues that you have, where you have the internet, which is highly addictive, and you combine that with the impulse to gamble, which is also highly addictive. So does this make the situation worse, especially maybe during a pandemic when people are sitting at home, and we have, sort of a new generation that's spending more of its time, this Generation Z, just wholly online. Are those concerns that you think state legislatures are tackling, or are they just kind of ignoring those issues, other than, as Professor Harmon suggests, in the southern states where this has always been a concern, but maybe for, with regard to slightly different ways of gambling, obviously not online.
I think I mentioned that I think it's something they want to tackle, but it's such a hard situation because I think most state governments feel they want to be hands off with their citizens in certain regards, not in everything, obviously, but they don't want to be overly controlling, which is why I'm surprised that I hadn't seen anything like what I suggested, like a maximum amount you could lose before your account gets locked for a month or something like that. I think they need to take it seriously because it's so easy to just, you could burn through your life savings at the touch of a button, unfortunately. So I'm surprised that I haven't seen more.
Yeah, I mean, it is interesting because, there definitely is a concern, especially about younger people. Maybe, I don't know if we've even looked into this, maybe Dean Crowley knows something about this, whether it's any kind of concern for our students, as to whether people are wagering more than they have, and whether this is some sort of behavior that people are manifesting, or whether it's just not something that we've seen yet.
Let's see.
Did you see, Mark, there's a question in the chat.
Yeah, from John. Let me read that. Professor Harmon, I think you muted yourself, so you know.
Yeah, I'll read the question out loud just so everybody knows what it is. John asks, generally, do existing sports betting websites factor in athletes/clubs cheating? Can the clawback winnings connected to discovered cheats?
John, I want to say that is another thing, unfortunately, I didn't see, but I think it's a very legitimate concern. And I think that goes to the federal government's concern of ensuring the, what's the word I'm looking for? The sanctity of the game, essentially, making sure that sports betting doesn't somehow overlap with, say, athletes purposely shaving off points because they bet on the other team or something like that. So my answer to you is I haven't seen anything specifically like that, but it's a very good, I think it's something they would have to consider because it's a very real possibility.
And I guess that segues into your, story about the 1919 Black Sox rigging. And you had sort of suggested that organized crime, excuse me, was not so much of an issue. It sort of receded in concern, but there's always a concern that it could resurface again. Are we seeing any trends in that direction?
The only thing I found about the criminal overlap with this had to do again with offshore betting sites. And it was less of a tangible concern and more of a, there are many countries abroad that don't have as strict laws or regulations about the sports betting industry, so it's possible. But I think a compelling argument in favor of repealing PASPA that I agreed with was having legal options really does hurt the illegal options, because when PASPA was just making it so that anyone who ran betting operations was breaking the law, bettors didn't really care because PASPA didn't concern them, it concerned the people running the games. So I think in the United States, the issue of organized crime might have dissipated.
Hmm. I mean, yeah, because it reminds me of there was an alleged MLB, Major League Baseball match fixing sort of allegation that was made in a few years back, around 2012 or 2013, where this gambler said that he was involved in fixing Pittsburgh Pirates games with the pitcher Jeff Locke. But then there was an investigation, and it was discovered that he didn't have any contact. So he actually was just mad at Locke. He knew him from when they were kids in youth baseball, and he created this story in order to damage Locke's reputation, and it wasn't really going on. So I thought it was kind of a weird story.
I hadn't heard that. That's an interesting one. Professor Kelly, do you have a question?
I wonder if you saw any connection between the gambling issues within sports and the ongoing conversation about amateur athletes at the collegiate level.
It's one of those, I didn't really focus on it. I think it's a very good topic because I can say that there were a lot of amateur athletes who participated in gambling point shaving schemes back in the 70s and 80s, because this issue has been one where they're not being paid, so they want to make money however they can sometimes. And that's actually one of the concerns that Senator Bradley raised when he sponsored PASPA, was that legalizing sports betting essentially turned them into almost bargaining chips, where they could kind of sell themselves to the highest bidder to make sure that they're satisfying the bookies or whatever. So the answer is I haven't seen it. I didn't get to see the overlap in the recent times, but I noticed it when I was researching older laws like pre-PASPA.
And also there are NCAA rules on sports wagering, right, for intercollegiate athletes, where they prohibit it, I think. So that would be sort of interesting to see whether that might change in any way. Because right now, as you would expect, the NCAA is taking the position sports competition is, at college is all about the inherent benefits related to fair contests and not the amount of money that's wagered on the outcome of the competition.
Yeah, absolutely.
But obviously that's still the second biggest area in sports. So maybe Mark will come back one day and do another paper on developments in amateurism.
I mean,
Mark, what about what are the, I don't know if this is the right way to say it, the brick and mortar casinos, or maybe I should say the neon lights and floor show casinos? What do they think about this kind of thing? Are they going to try to get in on the act and say, well, we've got a mobile, almost like all the bookstores had to get some kind of a reader associated with them if they wanted to, try to get into and to stay into the online reading stuff. With the, you know, traditional casinos, do they want to get in on this act?
The answer is absolutely yes. And I think what's interesting is, you know, Tennessee was one I always went back to. Tennessee only has sports betting online. So they have casinos, but you can't go in person to the casinos to play sports bets. You have to do it from a phone. But what I have seen is that casinos are getting in, pretty much like casinos at the state levels are getting involved. I mean, they don't wind up, I don't think personally, other than BetMGM, I don't think they really compete with the big ones like FanDuel and DraftKings, but they definitely try to get involved, because this is, you know, with Las Vegas, it was originally exclusively the casinos. So they kind of want to get involved in that too now. And they feel like maybe they've lost out a little bit.
And there's states like Colorado where you have to place a bet with a legal sports book or an operator. So I'm not quite sure how the casinos fit into that style of regulation.
No, in Mississippi, they had, you know, you could do the gambling, but it had to be on water. So everybody, they had all the casinos were on showboats on the water or on lakes, you know, and then Hurricane Katrina came along and lifted all the barge casinos, and they slammed them down on top of all the antebellum homes. So everybody's, you know, it's like, see, we knew this was wrong. Anyhow, any other questions for Mark at this point? We have about 5 more minutes. I think this has really been fascinating, and it's been an unusual, a very unique topic. We haven't had anything like this before, and we appreciate Mark doing this, and glad that he won, because we got to hear about something we haven't heard before, a different take on everything, a different field, and a fascinating one. I think it opens a lot of questions we don't have any answers to completely yet, but Mark's asking a lot of them, and I think he'll be part of answering them in the future. So that said, Mark, thank you very much. Thank you, Professor Fisher, everybody for zooming in and listening to Mark's great talk. Mark, we'll be sending you a plaque in the mail to commemorate your student scholar participation today. Everybody's clapping for you now with their virtual hands. So thank you for doing that. And we'll be looking for a story on the website very soon. So thank you all for coming, and we'll see you next year when we start the series again. Bye-bye.
Thanks, everybody. Appreciate
Thank you,
it.
everybody.